I promise.
I'm so sorry.
He's coming out here.
All right.
Thank you. Please be seated. Good morning.
Mr. Trustful went to the restroom.
Yeah, no problem.
Just get everything set up here.
All right. So you can be with me next week too.
Okay, sure. Thank you.
We approaching this, Judge?
Yes. All right, as I understand, we've had conferences concerning some of these motions in limine and various other matters. There are several matters that the state and defense are working out concerning some documents and whether or not they can be admitted. You continue to meet between now and next Monday, as I understand. Basically, I've just been advised and let the record reflect that Mr. Moorer is present. Mr. Trustlow, as I understand, you can talk with your client, and the state is prepared to go forward and establish all the requisite bases for admitting the statement, the two statements. Your client is no longer challenging those statements and the admissibility, and acknowledge that they were freely, voluntarily, knowing, intelligently made and given by him without any threat, and after being fully informed of his Miranda warning. Is that correct?
With one exception. We don't need the Miranda warning. He came in voluntarily, but that is correct, Your Honor. We are not objecting to it.
He's not challenging the
Not
statement on any constitutional basis.
And I would like to put specifically on the record which two statements we're talking about, the dates, and then yes.
The one that was given to Kenneth Canterbury, Your Honor, and the one that was given to John Martin.
Okay.
The one that was given to Kenneth Canterbury and the state and given to John Martin.
John Martin
Yes, sir.
with Alan Large and
No,
Honorable Martin.
sir. It was John
The
Martin
recorded
and Jeff
interview?
Cottle.
Yes, that's correct.
Those two statements. Very well. Okay. So that establishes that the state will be allowed and permitted to introduce those, and those statements no longer can be challenged by the defendant. They are deemed admissible. Now, Understand, however, though, it doesn't matter, because if we had a Jackson v. Dental, I would find by the preponderance of the evidence, I still will instruct the jury concerning the statements, and they're tasked with finding the statements were freely voluntary and knowing intelligently made and without any threat of coercion beyond a reasonable doubt. But otherwise, there'll be no challenge to their admissibility. Okay. All right.
Your Honor, I believe that just leaves
The motion.
5-1 motion.
That's what we have to hear from you.
Your Honor, the last remaining motion after withdrawing the other ones has to do with a motion to sever the two charges for trial. One charge is kidnapping, the other charge is obstruction of justice. I don't think, launch into the elements of each one of them. What I will point out is that the kidnapping is alleged to have occurred on the 18th of December. The obstruction of justice is a separate issue and has separate evidence. It is not related in kind or nature to the other case. The kidnapping involves the disappearance of Heather Elvis.
Right.
Whether this individual had anything to do with it. The obstruction of justice, as I understand it, is that at one period of time he indicated that he had not made a payphone call, and then he, when confronted within actually minutes, if not seconds, he said, "Yeah, I did make a payphone call."
Right.
So, without arguing, because that will be at a trial, but that's all that's limited to. My understanding, and certainly I don't understand how that goes as far if he corrected himself within a minute or 30 seconds, how that impedes justice or any resources were diverted or all that, but that's a legal issue for the trial on that matter. Mm-hmm. But in terms of putting the two cases together, I look at this case of State v. Beekman, and it contains a lot of the South Carolina case law in here that's been talked about in terms of this issue before you today. Cases have been joined at trial where there's a single course of conduct or connected transactions. It's been allowed where crimes involve connected transactions closely related in kind, place, and character. I don't see and argue that it is not the case in this case between the kidnapping charge and all that's involved with proving that and all the allegations, and whether or not he admitted to a phone call and a minute later said, or did not, and then a minute later said that he did, which is probably all in about 1 to 2 minutes of time during this whole incident. Also done well after the first alleged crime. So as far as in timing, kind, place, and character, they couldn't be more different. The case law, the last piece of law I would read out of Beekman was that it was okay to join where there's some chain of circumstances and a great overlap of evidence. We just don't have that here. It's really two separate charges with two separate fact patterns, two separate lists or evidence that would have to be presented to do each one of them. And for that reason, we would not like to be in a position to try two cases in one trial that are so separate and distinct. Thank you.
Thank you. Listen.
Thank you, Your Honor. Mark Sproul on behalf of the state. The state would disagree with Mr. Truslow's impression of these charges being completely separate. Your Honor, one clarification. The obstruction of justice charge was not alleged to have occurred during the interview with Detectives Martin and Cobble. Rather, it was alleged to have occurred during the interview with Officer Kenneth Canterbury at the defendant's home on December 20th, 2013, or 2 days after Heather Elvis went missing, according to the indictment that was issued in this case. It is during that interview that the defendant misrepresented his communications and his activities the night of the 18th to Officer Canterbury. And that is the allegations of the obstruction of justice charge, which the state will be seeking to go forward on a trial. Your Honor, I do have two cases I will be relying on. If I could, I have copies for the defense as well as the court if I could hand them up.
Sure.
Nice.
Thank you.
Your Honor, I'd first like to reference State v. Harry, located at 321 South Carolina 273. It's a 2001 case. In relevant portion, Your Honor, regarding a severance motion, the court in that case lays out the basic test for whether or not charges can be tried together. Charges can be tried together, according to the court in Harry, if they arise out of a single chain of circumstances, are proved by the same evidence, are of the same general nature, and no real right of the defendant is prejudiced. In Harry, Your Honor, the court found that an arson and a later false insurance claim were properly tried together because the false insurance claim was related to the arson.
Sure.
Here, the obstruction of justice charge is related to the kidnapping. It is, in fact, the investigation into the kidnapping where the obstruction of justice occurs. It is during an interview with the defendant about his location the night of the kidnapping where the obstruction is alleged to have occurred. So clearly they arise out of a single chain of circumstances, that being the kidnapping, the investigation, leading to the obstruction of justice. They are proved by the same evidence because the defendant's statement to Kenneth Canterbury, as well as his false statement to Kenneth Canterbury, the state alleges, would come into evidence at the kidnapping trial as well as the obstruction of justice trial. So all of the same evidence will be presented by the state in regards to these in the kidnapping trials it would be for the obstruction of justice charge. Furthermore, there is no right of the defendant that is prejudiced. Again, these all arise out of the same circumstances and the same investigation by law enforcement. And basically, Your Honor, regarding the general nature, these are the same general nature because, as the court says in Harry, these charges arose out of a single chain of circumstances, beginning with the arson and continuing to the false insurance claim. Furthermore, much of the same evidence would have been admissible at both trials. The charges are of the same general nature because they are interconnected. Just like here, the kidnapping and the subsequent obstruction charge are interconnected. Your Honor, I was also referenced State v. Rice, located at 368 South Carolina 610. For summation, in that case, Your Honor, a suspect was sought on a murder charge. When he was arrested, he was found to be in possession of trafficking weight of cocaine. The court in that case, in Rice, did say that it was appropriate to try both the murder and the subsequent trafficking in cocaine because they all arose out of the same chain of circumstances, the same chain. One other case, Your Honor, I forgot to hand up, but I'll hand up at this point to the defense counsel and the court, is State v. Tucker. State v. Tucker, which can be found at 324 South Carolina 155, which is a 1996 case, in summation states, it's where a man committed a burglary in an effort to elude capture on a murder charge, similar to the way the state is alleging that this defendant committed an obstruction to elude detection on a kidnapping charge. In Tucker, the court said it was appropriate to try the burglary charge as well as along with the murder charge because they did arise out of the same chain of circumstances. The subsequent burglaries were done, in fact, to avoid detection on the murder charge. So for those reasons, Your Honor, relying on those statutory case law authorities, the state would ask to be able to try the obstruction charge and the kidnapping charge at the same trial.
Let me ask you a question before I hear from counsel in response. What's the prejudice to the state?
The prejudice to the state would be judicial economy as well as the expenditure of state resources in trying these charges separate. The evidence is the same that will be presented at both trials.
Would you agree with me that the obstruction of justice charge trial would involve one witness, maybe?
The obstruction of justice charge would likely require at least 3 to 4 witnesses by my math.
We could talk about minimal.
We are talking about a much simpler case, Your Honor, than the kidnapping trial alone. However, since they all arise out of the same
And would you agree also that we're getting into an area where the person's being examined as possible suspect in the crime in these really particular areas concerning constitutional rights.
Your Honor, in regards to the statement to Officer Canterbury on that night, at that time the defendant was not a suspect.
I understand. Well, let's just for the sake of discussion, and we're not trying this case, if he changed the statement and corrected himself, and you're going to have that anyway, the state already has the evidence, and whether it's significant to the kidnapping charge or not, I guess it's arguable as a trial lawyer. But from the standpoint of you're going to have that testimony is going to be rendered in the kidnapping trial. This is not so. There really is no prejudice to the state insofar as keeping any evidentiary matters out that would otherwise relate themselves solely to the obstruction of justice. I agree with you that there's an overlap, but clearly that evidence is coming in anyway.
It is, Your Honor. One clarification. The actual, and Mr. Tressler has said, one thing I may have gotten to correct in misrepresentation, or what I see as potential misrepresentation, is that Mr. Moore did not come clean immediately to Officer Canterbury. It was several days later.
And that, to me, gets into the point of clouding the issue that really and truly doesn't need to be, because that may or may not be an obstruction of justice. And we get into squabbles even with fact finders about whether that was or was not, and loses sight. You would agree with me that the most significant charge we have here is the kidnapping charge.
Yes, Your Honor. The kidnapping is the most serious 30-year offense.
And that is the one that's also going to require most of the proof. We agree with that.
The vast majority of the evidence will be going to the kidnapping charge.
Okay. Thank you, Solicitor. I appreciate it. Thank you. Reply.
Nothing, Your Honor.
Okay. I will read your cases thoroughly, and we'll let you know. We'll send an email to both of you concerning our ruling. It'll be either today or tomorrow.
Thank you, Your Honor.
Thank you so much.
Thank you, Your Honor.
Appreciate it. Anything else? Now,
Nothing from the defense.
anything from the state?
Do not believe.
Your Honor, we've resolved everything. We brought several witnesses in preparation. We'll let them go if Mr. Tressler didn't have anything further in the
Very
judge.
well.
We're not going to hear any motions.
We're not. Thank you.
We'll let them
Appreciate
speak
that.
then.
If anything comes up that we need a conference between now and Monday, just give me a call. I'm in Charleston with GS, but we can arrange some work with some pleas around if I need to make another trip back. Okay?
Yes, sir.
Thank you so much.
Thank you, Your Honor.
Y'all have a good day.
Thank you, Judge.
Y'all have a good weekend.
I know. Let me see y'all just a second.
You want to check?
Yeah, just want to check. Just line that up. Doug. How many witnesses do you all anticipate?
For next week, I can.